Good morning, this is your Kelso Report for Tuesday, February 28th, and I'm your host, Clark Kelso. Today we've got cases dealing with the death penalty, juvenile law, criminal law, labor law, and arbitration. We begin with a death penalty case in the Ninth Circuit. The petitioner had filed a pro se habeas petition in federal district court. The court appointed counsel, who then filed an amended habeas petition raising 8 substantive claims of constitutional error, as well as numerous distinct allegations of counsel ineffectiveness. However, counsel did not include the petitioner's Eddings-Tennard claim in the amended petition. The district court denied the petition and the Ninth Circuit affirmed. The defendant then filed a motion for relief from judgment to seek the opportunity to litigate the Eddings-Tennard issue as a new claim, which the district court denied because of the bar on second or successive habeas petitions. The defendant argued for an exception to the bar on grounds, creative grounds, that his counsel had abandoned him by failing to present the claim in his amended petition. The Ninth Circuit rejected the argument that the petitioner had been abandoned. As the court noted, counsel did not engage in egregious professional misconduct and certainly did not leave the petitioner without any functioning attorney of record. The error just wasn't that serious. In these circumstances, there was no need to consider creating an exception to the bar rule for abandonment, since factually there simply was no abandonment. The Ninth Circuit affirmed dismissal of the habeas petition. Next case arising under the juvenile law, California Court of Appeal decision. The juvenile court's dependency jurisdiction is strictly defined and limited by statute. And when the court decides to dismiss a dependency petition after holding its jurisdictional hearing, it loses its jurisdiction over the minor who was subject to the petition. Well, that is what happened in re Ashton R., where the juvenile court dismissed a petition with respect to Ashton R., thereby terminating the court's jurisdiction over him. In a subsequent proceeding regarding Ashton R.'s half-sister, Ashley, the court ordered supervised visitation between the siblings. But the First District correctly held that this order was in excess of the juvenile court's jurisdiction, since it no longer had power over Ashton R. or over Ashton R.'s father, who was not Ashley's father. As a result, the First District vacated the sibling visitation order. Next, a criminal law case, rather interesting one. One Jose Contreras Cazares was recognized during a traffic stop as someone who was wanted for arrest. When the officer asked him for his name, the defendant said his name was Tony Contreras. He consented to a search, and the officer discovered a white piece of paper in his back pocket. The defendant claimed it was a birth certificate and would prove he was Tony Contreras. Well, it turned out, of course, the birth certificate was forged. He was convicted under Section 529 of the Penal Code. It's one of the original 1887 versions of the Penal Code, provisions from the Penal Code. Convicted for false personation. Well, in People v. Cazares, the Fifth District reversed the conviction because Subdivision 2 of Section 529, under which he was prosecuted, required more than mere presentation of a false identification. Instead, it required that the false identification be used to create or exploit some other written instruments, such as a contract or an application for a credit card or a loan. There was no such evidence of additional use in this case, so the court reversed the conviction for insufficient evidence. There are other provisions within the Penal Code he could have been prosecuted under. The district attorney simply picked the wrong choice. Next, we have a labor law case. Now, in 1999, the legislature enacted Section 512 of the Labor Code, which requires employers to provide a meal period of at least 30 minutes for a daily work period of more than 5 hours. At the time, the section was enforced only by the Labor and Workforce Development Agency, and there was not much enforcement because of resource limitations. But then in 2004, the legislature enacted the Private Attorneys General Act, which authorized, among other things, individual employees to bring suit to enforce these labor law provisions. Ever since then, we've seen a growing amount of litigation against companies for alleged violations of the meal and rest rules. In Thurman v. Bayshore Transit Management, the 4th District reviewed a judgment entered in favor of a single employee who was awarded some $350,000 in civil penalties, unpaid wages plus prejudgment interest. The court affirmed the judgment on liability, but it reversed on the measure of damages, because the plaintiff had conceded in its original complaint, filed some 6-7 years ago, that the defendant had actually offered mealtime after the year 2003. The 4th District held that this constituted a judicial admission which bound the plaintiff, and the plaintiff's damages recovery should therefore be reduced to reflect that admission. Finally, an arbitration case. Now, as I have noted frequently before, California state courts tend to be pretty hostile to arbitration clauses. I think a good example of that tendency to strike down such clauses pretty quickly is the decision in Mayers v. Volt Management Corporation, where the 4th District refused to enforce an arbitration clause in an employment contract because the employer failed to specify clearly which rules of the American Arbitration Association would apply to the arbitration, and to make a copy of those rules available to the employees, and because the prevailing party attorney fee clause in the agreement tended to favor the employer as a practical matter, compared to the attorney's fee provision available under the Fair Employment and Housing Act. Well, those two considerations were enough for the court to refuse to enforce the entire arbitration clause, and the case will now proceed in court under the Fair Employment and Housing Act. It really is a hair trigger for declaring portions of arbitration unenforceable, at least before some California appellate panels. And that's it for today's Kelso Report. Have a great day in the law.